Our next speaker is William Kozlowski. William is a partner in the law firm of Kozlowski and Kozlowski, located in Utica. William has served as a law guardian or attorney for the child since 1998 in both the 3rd and 4th departments. He has presented numerous lectures at training conferences on the UCCJEA, UCCJEA, PKPA, international and intrastate child abductions, and the rights of disabled children. He has been awarded the Honorable Michael F. Dillon Law Guardian Award by the 4th Department, as well as numerous other awards. William has been a member of the Boy Scouts of America for over 55 years. He's an Eagle Scout. He's also a recipient of the Whitney M. Young Jr. National Service Award for Outstanding Service to Disadvantaged Youth in Scouting. He serves on various national committees for scouting and served as an executive board member of the Revolutionary Trails Council in Utica for over 15 years. Join me in welcoming Bill Kozlowski.
Thank you, Linda. Very kind and very nice opening. I'm humbled to be here. I think I always have. Ready? Louder? At me, okay. I'm humbled to be here. I've always said that when everyone has asked me to present, and at the same time, I'm always nervous as to the delivery of the presentation, and hopefully I'm not going too fast or too slow, and I certainly do not want to presume that everything that I'm going to say you don't necessarily know. So what I'd like to do right now is to give a mini perspective on what we're going to do today and give you a reaction on what I used to see people and how they used to react when the term UCCJEA was mentioned. The most common reaction that I saw was a facial expression, and that was a sour face. Ooh, I don't want to talk about the UCCJEA. It's weird. So I thought possibly that maybe there was something in the UCCJEA that would cause people to have a sour face. Hence, I came up with the acronym, and this will be, in essence, the outline, the general outline of our presentation. Whenever you think of the UCCJEA, think of it as a lime, L-I-M-E. L, it's the law, and it applies in 3 specific areas: initial child custody determinations, I, M, modification of child custody determinations, and E, enforcement. Not that difficult. Thank you. I'll come back another day. No. All right. But that's the general framework. Why do we have it? A long time ago, when we were part of England, the king or the queen, they made all the decisions. We broke loose, and we came to become a country. And at one point in New York State, our courts were called the Court of Common Pleas. And family court, in the beginning, was children's court. But were there all kinds of rules dealing with venue? How do you deal with conflicts when a child and or a parent was in one state or in one county? The answer is no. Things began to get complicated because people no longer needed to ride a mule or a horse to get around. They had cars, they had trains. Later on, we became a highly mobile society, and more jurisdictional complaints began to pop up. Now, in the beginning, venue. How did you decide venue? I mean, should it be in Otsego County or should it be in Onondaga County? The only real guideline in the beginning was either court could decide where the case is going to be heard, but we had to have some kind of connection, a connection between the counties. And that usually was, does County A touch County B? Are they tangential? Do they have any little teeny tip of contact? And if they didn't, it was up to the creatures called judges to decide. They will decide, I want this or I don't want that. Those rules no longer could be applied because they were unfair. We started off with an experiment called the UCCJEA, the Uniform Child Custody Jurisdiction Act. Not every state followed it. There were inconsistencies in the law. There are parallels to the UCCJEA within the UCCJEA, but it wasn't working. And because of that, Congress thought we have a better idea. And what we're going to do is we're going to pass a law called the Parental Kidnapping Prevention Act. And frankly, it had nothing to do with kidnapping, but it sounded good. And the real purpose behind the law was to try to give some kind of cohesive treatment between competing states, between competing jurisdictions on how to go about and enforcing laws and hearing cases and giving people a fair chance. The problem with the UCCJEA was there wasn't an E in it. There wasn't an enforcement provision in it. So consequently, what the federal government thought is, well, maybe if we have a federal statute called the PKPA, maybe we can rely upon this archaic document that exists in Washington, D.C., called the Constitution of the United States, and try to rely upon the Supremacy Clause so that if there were conflicts between State A and State B, and neither state would budge, maybe then we could employ the good offices and the good legislation of the PKPA. And that tried for a period of time, and they tried to work that, and there were some cases that came out on it, but after a while it was still a mess. Hence, the commissioners of all the various states decided to get together and create what's now known as the UCCJEA. Now, in my outline, I did give you a list of abbreviation. Hopefully you thought that was for your benefit. It really isn't. It was for my benefit. Because if I had to go through Uniform Child Custody Jurisdiction Act and person acting as a parent over and over again, I would be hoarse within probably the next 21 minutes. So throughout my outline and some of the cases that I gave, breaking down what's been developing, I use those terms, and I would ask you please to make reference to them. UCCJEA, where are we now? Well, it's the law. It's the law in every single state. I raise that because about 3 years ago, a judge from St. Lawrence County contacted me and said I had a really bizarre case dealing with Massachusetts. The Massachusetts judge says we only adopted a part, only a portion of the UCCJEA. Wrong. Every single state has, in fact, adopted the UCCJEA, not bits and pieces. It's consistent. Practice point, when you get a case that deals with different jurisdictions, i.e., let's say Iowa and New York, do yourself a favor and look up the UCCJEA in Iowa. Try to match them up as to the provisions and try to match them up to our provisions under the DRL, the Domestic Relations Law, to see where they match. And use them either in your argument to the court or in motion papers. And also, that helps the overworked law clerks, court attorneys in our system get an advanced start. And it might even help the judges when they read it to say, hey, you know, this seems to be out of whack, or it seems to be in compliance, and how can I use that in my decision? The whole purpose of the UCCJEA was to promote uniformity across the country and internationally. Internationally was an overbite because our commissioners and our states have basically said it's going to be binding across the world. Good luck. Some cases, some countries will do it, other countries will not do it, other countries will perhaps consider it. If they're not a Hague country, a country that is a signatory to the Hague Conference on International Abduction, you're not going to get anywhere with it. But, you know, our commissioners nevertheless said this is what it is. The UCCJEA is procedural. There is a difference between procedural law and substantive law. You know that, I know that, but other entities may not know that. It is procedural. It is purely a procedural statute. That's what I'm supposed to tell you, and I'm going to give you a little insight. But there are ways throughout proceedings to inject substantive law within the context of this procedural statute. Am I going to tell you now? No. Am I going to keep you baited until later on? Yes. So let's go. Some of the definitions that I put down, I said, well, anyone knows what a child is, but, should I put it down or not? And the reason why I put down what is a child is a person under who's not 18 years old, was basically this. Two reasons. A recent case in New Jersey where people spent probably $100,000 to litigate a case dealing with a 17-year-old, 10-month individual. Should it be in New Jersey? Should it be in New York? Does it care? Do we matter? Why should we? Because when the kid turns 18, it's over. The other one that I found really interesting was a case from California. Mom and dad lived in California. They grew up in California. They conceived a child in California. All the natal, prenatal care, all the relatives lived in California. Mom decided, probably upon advice of counsel, right before the birth, why don't you fly to New York? It's a good place to go. And sure enough, landed in LaGuardia. 2 days later, gave birth. Daddy was very unhappy. He filed a petition for custody. Mom filed a petition for custody in New York. Guess who won? Mom. The child wasn't born. Unborn children are not covered under the UCCJEA. When we talk about, and the statute uses the term child custody determination, and I reference that as a CCD. A CCD means it has to deal with custody or visitation. If it deals with pickles, it doesn't have anything to do with custody. If it deals with child support or adoption, it doesn't have to do anything with custody. If you get a judge in Iowa to give you a stuffed pig as part of an order, it doesn't deal with custody. Any orders that are made have to reflect an impact, have to reflect the issue of custody or visitation. What could it be? Well, sometimes you get a combination. People don't like each other anymore. They have kids. They sue for divorce. It's very possible that you can have an action commenced in another state that is divorce, and they have jurisdiction for divorce, but they may not have jurisdiction for custody. So whenever you see any of these judgments or decrees that deal with divorce, always take a look and see whether or not the issues of custody were therein. If they were not there within, they do not apply. It includes, here in New York, separation agreements, separation actions, neglect actions, abuse, dependency. We don't have dependency in New York. That's a fancy term for some states saying PINS or JD. And paternity, TPR, protection from from domestic violence. Again, what the UCCJEA does not embody, it does not embody JD, PINS, contractual emancipation. We don't have it here, don't worry about it. And it does not deal with adoption. Okay, many years ago, I had a nice case where two of the judges found me outside the courtroom and they brought me in. They closed the door and they said, "You're going to represent this lady." And I never saw her. And the kid's gone. We don't know where. And I said, "Well, can I talk to my client?" "Good luck," because she spoke no English. She's Taiwanese. So after we got an interpreter, I began finding out the following. Severe victim of domestic violence, severe. Beaten like a pulp. Guy came back, took the child, skipped out. We couldn't find him. But we filed the petition seeking custody. 6 months, 8 months later, the guy pops up in Oregon and contests jurisdiction. I've been living here in Oregon. I wish he lived in Salem because he would have been a warlock that should have been burnt at the stake. But our court would not let go of the case because we started the action. Service wasn't required. We got him eventually through substitute service. Long story made short, after I think 6, 7 months of litigation, we did get the child. The father did appear by an attorney only, and then he disappeared. 3 years later, with massive help, we found the child in Taiwan. The child was skipping from Indonesia to Malaysia. We finally got the kid in Taiwan, and the Taiwanese authorities, who are not an official nation recognized by the United States, did assist us in returning the child to the mommy. Again, just the key reminders, keep in mind that custody or visitation has to be an issue. Commencement starts when you file the first pleading. Home state, you're going to hear a lot about home state. Home state is where the child has lived with a parent or parents or a PAP. A PAP is a person acting as a parent. Julie Geruzzi went shopping at Walmart one day, and she saw this wonderful little child, and she said, "Boy, I wish I had him as my son." And of course, because she's ethical, she's, said, "This kid's missing. Nobody can find him, or the parents. He was just left off at the lingerie section." Okay, that's where he was. And after 6 months or so, the child still was living with Julie. No parents ever came out of the woodwork to claim him. No litigation was started earlier. Well, among other things, Julie now is going to be known as a PAP, person acting as a parent, because she had him in her home. She was raising him. She was taking care of him. And now she has acquired a status as a party called a PAP party. And so in the future, if the parents ever come out of the woodwork, like Oklahoma or Minnesota, and they say, "We want our kid back," she would have the right to say, "This is home state. This is where the child has lived with me in my home for at least the past 6 months. I can claim it." And any litigation here should be resolved by the court stating that jurisdiction for home state purposes under 76(1) of the DRL is New York State. Temporary absence. I wanted to avoid this a little bit, but I'm not. Temporary absence means temporary. It does not mean permanent. And I'm going to go into a far more explanation of temporary absences, but I cannot resist the temptation to tell you the following, which is developing in State A and most likely in the appellate division to be filed in the 3rd Department. Mom and dad have a child. The mom and dad lived in Tennessee. Oops, I told you the state. After 3 months, they moved to New York. The child is 4 years old. And then mom, and I could not make this up, mom on Valentine's Day says this: "I want to go and visit my mother near Memphis." Wow. Daddy bought a ticket for her, plane ticket. She flew down to Memphis to stay with her mom and her relatives. The boy stays here in New York. After mom gets down there, mom says, "Our son's birthday is March, early March. Would you mind bringing him down to Memphis so we can celebrate his birthday?" And Daddy says, "Sure." He goes down. They have a nice birthday party. And then what happens? At the birthday party, the maternal grandmother gives a present to the father. You're served. All right? I look at this and say, okay, you lived here for 6 months. This is a temporary absence. Have an attorney in Tennessee file a motion for a limited appearance to contest jurisdiction, and that should be the end of the story. For the first time ever, and there are absolutely no reported cases on this point in any state except Tennessee and New York State now, is this. What is a temporary absence? Does a temporary absence mean that the child and a parent or a PAP or both parents must stay in the same state exclusively for 6 months? Can't leave? Like you can't go to Pennsylvania for a day, or you can't go to Nashville for a birthday party? Tennessee judge says once the 6 months is broken, you got to start all over again. Now, respectfully, he's nuts. But outside of that, we have a problem. That case is going to go to the appellate division in Tennessee, and we'll be doing an appeal here in the third department. What happens, let's say that all goes smooth, and you can demonstrate that your state has home state jurisdiction. Whenever you have an initial child custody determination, that means it's over. It means that once you get an order of custody or order of visitation, possibly even, I know possibly's about it, a grandparent visitation case, it's over. Anything that was litigated includes not only law, like did you have jurisdiction, was this in the best interest, it also embodies facts. So if anyone ever tries to tell you you can peel away a portion of the case and the UCC only applies after the initial child custody determination to be applicable only to law or only to fact, wrong. They're totally wrong. There's no case out there at all, even from Tennessee, that would authorize such a conclusion. What is a PAP? You know, I used politely Julie as an example, but a PAP can be anyone. A PAP can be human, it can be a government entity, it can be an aunt, uncle, it could be a non-relative. It's a very broad item, very broad definition for inclusion into what a PAP is or is not. And of course, once you get a final order by a court having jurisdiction under the UCCJEA, it's entitled to full faith and credit. You can't say, well, that's just a New York order, we're not going to follow it in New Mexico. It's across the board, it's binding. Again, any Hague countries, any Hague signatories will honor it. Any non-Hague countries, that's up in the air. When you start a case where jurisdiction is contested, you can ask for a priority. You should get a priority from the court to hear the case. Why? Time is of the essence. Do you really want to fight out what state has jurisdiction over several months and then finally get a decision way down the line? No, you don't want that. Why? Because you know darn well your opponent in either the other state or this state's going to say, oh, there's been too much time passed. There's too much time. We think the kid should stay, and New York should say, we don't want jurisdiction anymore. We will say it's an inconvenient forum. Let's pass it down to the other state. Fortunately, no appellate decisions have bought into that argument. If there's a delay, there better be a reason. And if it's not the attorneys or the other attorney or the AFC, then they're going to be looking at the person on the bench. Why was there a delay? Why wasn't this expedited? Do you need more schooling at the Judges Institute? Maybe you need some help. And I take it very serious, in part because we all know how cases are kicked down the road. Initial appearance, preliminary conference, pretrial conference, trial, half day. That's not good. Okay, let's say that you get somebody in the state of Kansas and they're not going to come. No way, I'm not coming back here with a child. Forget it. I'm in Salina, Kansas, and I like it here. I'm not coming back to New York. Well, guess what? We can't order, the court cannot order a party to come back into New York State. The court can order notice, must give notice, and give ramifications as to what's going to happen if you don't come back. Choice A, you're going to go to Mars. Choice B, most likely you're going to lose the case. Choice C, we got some other things. The court could order the party seeking the return of the child expenses. Go out, file a petition somewhere, get the kid, and come back. I haven't seen too much of that because the courts generally, shouldn't say it, are generally right. They want stability and lack of disruption for the kid. So they kind of hedge on, well, we'll just keep the kid in the other state and we'll remember what the other parent did. But they won't say that officially. How do you give notice? You take a look at the CPLR. Any notice that's permissible for service under the CPLR is acceptable under the UCCJEA. You can do it in any manner in which the service of process is authorized in another state. South Carolina has some pretty neat ways to serve people. And when I ran into a problem a couple years ago in serving somebody in South Carolina, I found a neat way of getting it. You can serve their next of kin. And I go, hot dog. They didn't say what kin was, so I figured kin could be maybe the next door neighbor who was very friendly, who knows. But we found next of kin, and we served the next of kin, and it stuck, okay, which was really great. The other thing is, this is where the judges can feel more powerful because they can determine on their own service in any manner in which the court believes will be reasonably calculated to give notice to the other person, okay? So it's broad. A person can come up, let's say the Kansas lady, corn season is done, she wants to come. If she does come here, she can make a limited appearance without subjecting herself to the whole jurisdiction, okay? Most people don't know that, which I like, because they come up here, they subject themselves to the jurisdiction, and either with or without an attorney, they don't say, we're making a limited appearance. Thank you, okay? That's good stuff. Courts are required to communicate with each other, and later on in one of the 3 cases I'll be mentioning, we'll talk about issues of courts communicating with each other and not communicating with each other. The law is kind of fun. And the law basically says there are mandatory times when the court must, that's a 4-letter word, that's good, must communicate with each other, and then the 3-letter word, may. And usually the may provisions do not deal with significant rights dealing with a party's constitutional or statutory rights under the law. It's like, let's say that you get a judge who wants to talk to another judge and he knows there's simultaneous proceedings going on. What he or she could do was, I really don't want to send a letter to this judge. I'm just going to call up and say, hey, Schmo, how you doing today? Good. Hi, Joe, how are you doing? Well, we both got these cases here and we're going to have to coordinate something for a conference. Okay, that's fine. They're not getting into the merits of the case. They're not getting into the procedural aspects. They're not doing anything that's improper other than reaching out and touching contact with each other. That's okay. But there are other areas that we'll be talking about where it is definitely required that you, as the attorney and your client, and if you are the AFC, your client conceivably could be there. I don't usually see that very much, but you got to be there. It's not these smoke cigar filled rooms where the 2 judges hopefully smoke tobacco in the room and make a side deal with each other. That's not what due process is all about. With the UCCJEA, you have a lot of mechanisms that unfortunately are rarely applied within some of the counties that I deal with. And one of the items is that you can get make requests for hearing to occur in the other state. That has to go through the other state, and it may require the other state to approve the order request and make the order in that other state directing that a hearing will occur for use within the court requesting it. In other words, New York could say to Georgia, hey, we need a hearing, part of a hearing taken or testimony taken in Georgia. Would you authorize it? Send a letter down, an order. The Georgia court is obligated to follow that, and then they would issue a Georgia order saying do it. So I don't see that being done very much, but it can be done. The one item that I do like, one I've not seen yet, is depositions. Under the UCCJEA, you can ask that depositions be taken in another state, and naturally that can be enforced and done. And also video. I like that. The judges always have said in the past, or court decisions have said in the past, the trial judge is in the best position to observe the demeanor of the client. All right, what's kind of hard when it's just on a telephone, because you don't know whether the person is in their pajamas. But if they are on video and you can see them and the court can see them and you can that satisfies the right of confrontation, the right to examine. But then again, you have to ask, how is this going to be done? Practically speaking, I've done it. We've done it a couple times in Oneida County. One time we ran into an obstacle because it has to go through the portal from the other state, has to go through OCA in New York City, and then OCA somehow sends it up here. But those are not impossible means to achieve. Okay. Jurisdiction. Now we get into, aside from my stopwatch falling on the ground, I'm going to rely upon Linda to let me know when my 30 minutes are up. Good stuff. All right. Once you start looking at beyond the definitions and beyond what the preliminaries are, you get into the nuts and bolts of the UCCJEA. And again, it's broken down into initial proceedings, modification proceedings of the initial CCD. Initial CCD is the initial child custody determination order, and enforcement. So let's take a look at initial. The bases for exercising jurisdiction under a UCCJEA DRL 76 is not smorgasbord. It is not a Chinese buffet where you can go and pick what one you want to use. Niet, which is Russian for no, okay? You got to go through some hoops, like you got to follow the law. And the first part is you have to determine whether a state is the home state of the child. That's it. Okay, what does that mean? 6 months prior to the commencement of the litigation, the child and a parent or parents or a PAP, like Julie, lived in New York State. And if you satisfy that, it's over. At that point, it's over. You can't say, well, like my Tennessee judge down in Tennessee, that's why they call him a Tennessee judge. Well, they didn't stay there for a full 6 months. They broke it up. No, if there is a state that meets the prerequisite and meets the requirements of UCCJEA for 6 months prior to the commencement, you're stuck. You can't pick and choose on other stuff. Next, let's say that you cannot find a state that satisfies the 6-month requirement. 2 of the judges bordering Vermont and one in Massachusetts, when I did a seminar a little while ago, raised the issue of nomads. And they go, we get people who travel all over the place, but they never stay put. They never stay put. You know, they may go to Vermont for maple syrup tasting contests, and then they stay there for a couple of weeks, and they come over to New York, and then they go to Pennsylvania, but they never stay put. They just like wander. And what do you do in a situation like that? On that situation, you take a look at subdivision 2 of the DRL 76. Another state is not the home state or has declined jurisdiction, and there are significant connections to the state, New York, that others do not have, and the child, it has to be more than just physical presence, and there's substantial evidence that exists in the state that regards the future upbringing of the child. So you can satisfy it that way. The other one is, let's say that there is absolutely no state, nobody wants this case, okay? They lived in Alaska, then they traveled to Florida, they got bit by crocodiles, then they went up to New York, got bit by Texas, and then they went someplace else. Nobody wants them. So if there's no state that can exercise jurisdiction, then any state can, okay? And I've only seen a couple of them, but it's fine. Key reminders. Once you establish jurisdiction, it becomes the exclusive basis for the proceeding that's before the court. What happens if the lady in Kansas decided to go back to Kansas and there was an adverse decision against her here in New York, and then she left with the kid or never brought the kid here? Does that mean that the order is invalid? No. Does that mean that there's probably going to be an enforcement proceeding in Kansas to get the child? Yes. Does that mean that the mommy is going to win? No. Unless the judge was intoxicated or incompetent, or her attorney was incompetent and she didn't hire another attorney, she's going to be stuck. So when you make the orders, understand that if you're representing a person out of state, basically warn them that if you don't come in, you could suffer the consequences big time. If you have a state that is home state and the judge is complying with the law, which is a good thing, and the judge says, I'm not going to let go of it, you're stuck. If they have home state jurisdiction under 76-1, and the judge says, she says, he says, whatever, nope, I'm not letting it go, it's here. Okay? They have the right of first bite, and they have the absolute monopoly of this case. Okay. Let's say that the court issues an initial child custody jurisdiction, a child custody determination, a custody order, a visitation order, and it's done, okay? Of course, what do? You're happy, you celebrate, you serve the other party, there's a stamp on there, okay? That's good, filed. Once that happens, almost, New York, or any state that has home state jurisdiction, would have what's called ECL, exclusive continuing jurisdiction. That means when the case is over, the judge can't put it on a shelf or the clerk file it away. It's here. And it stays here until the judge or the court, however you want to call he or she or it, say it's no longer here. What I tell people is that there's a little quirk in our law. And understand that not every state has as many procedural steps that New York has. Sometimes we get certificates of mailing on our orders. Have you seen them? And they look pretty, and the clerk signs them, and the clerk puts down this and that. Whenever I have a UCCJEA case, I don't rely upon the certificate of mailing. I do a notice of entry. Because what the UCCJEA requires is notice of entry has to be given to the other party before you get exclusive continuing jurisdiction. Now, can you argue that the certificate of mailing is the same thing? I guess you could. I guess you could take a risk in screwing up your case or your client. But what I would say to you is why? Why take it a chance? How long does it take to make a notice of entry? If you don't want to have a separate piece of paper, go down to the nickel and dime store or whatever store, get a rubber thing, boom, stamp it on. That's it. You protected yourself. Some states are weird because some states don't understand how we categorize orders and finality of orders. So let's make it easy for them. Okay. One of the cases that, what time is it? Anybody can give you a clue?
11:10.
Good. One case that I think best illustrates initial child custody determination is that one that we handled here in Oneida County. And before going into that, I'm going to ask you all, please, please, whenever you draw up petitions or do amended petitions, whenever you do motions, be extremely alert and detailed for time. Put down the times. Don't say, well, the summer of 2016 until such and such time. Put down exact times, because exact times are often the means whereby a higher court, even the lower court, will determine whether there's proper jurisdiction. Most appellate courts don't do it, which drives me crazy, because you're reading these decisions and you don't have a time frame. I presume that they had the time frame in the briefs, but they don't want to share it with us. We don't count. I don't know. But put it in your papers, use it in your motions for stay or for dismissal. They're extremely important. The Ohio case. Ohio case is an interesting case, and it illustrates the initial child custody determination. Mom has 3 children. 1 child was born in Ohio. 2 children were born in New York. The oldest child has a father that evaporated. He went away. Never seen him again. Good. After that child was born, Mom met somebody at a fair and went and moved to New York. She had 2 kids with a child in New York. They stayed in New York for 2 years. Then the family leaves. All 3 children, daddy of the 2, and the mom moved to Florida. In Florida, it was a living nightmare. The father was admitted several times involuntarily to a mental hospital. The father committed severe domestic violence towards the mother. We had no information whether he did anything to the kids. Dad was convicted, did some time, was put on probation. Even after probation, he began to beat up the mother seriously. And there was a condition on his probation: he can't leave the state of Florida. Oh, I'm sure my client was very upset by that. So one day when he went to the probation or parole office, I'm not sure what now, she decided it's time to go. And she went back to Ohio. It even rhymes. And she lived there for about 2 years. He gets off of parole. He comes up to Ohio, and can I have the kids? No. He goes back to New York, and he files a custody petition. I'm the father, and I want custody. It took our court over a month and a half to appoint assigned counsel for this lady. And all during that time, she did not have any contact. Oh, I forgot to tell you. How did he get the kids? Well, Mom told his parents, I have cancer, and I need accelerated treatment quick. Can you help out? That was in July of that year. I'll let you take the 2 kids, and as long as they're back for school in September. 2 kids go. Mom gets a lot of chemo treatment at Cleveland. And the father, or the man who's not the father of your child, encourages the grandmother, can you see if you can get her? Can you get Gracie? Mom's very sick. She couldn't take care of the kids. Kids come to New York. September 1, guess what? You don't come. The kids are not back. Ohio State Police and New York State Police assisted in the recovery of the child who was not the biological parent, not the biological child of the father. Okay. Dad files a custody petition. We go in. It takes a month and a half to get an attorney assigned. Law guardian was assigned about, AFC was assigned about the same time. I decided not to file a petition in New York. Terrible of me. I decided to make a motion to dismiss on the basis of jurisdiction, that there was no jurisdiction in New York State because the children had lived in Ohio for about 2.5 years, but for from July until September of that year, legally, okay? The court wanted an argument, fine. We schedule a motion date, fine. We do our motion, fine. And the court says, I'm going to reserve on that. We need a hearing. Okay, so we have a hearing. And the hearing took place in December of that year. Now, everyone knows that nobody should talk to kids about litigation. Nobody should say to the children, Mommy and Daddy are fighting for custody. Well, the father was really good. He never told the kids. The father and the grandparents never told the children. And my client couldn't because she was blocked on the phone. All her letters were never given. And besides, how is it that a mom could call the children and write the children when Daddy told her she's dead? Yeah, okay. So in December, my client is alive. She wants to see the children. And at that point, the father said, well, that's going to be hard because she's dead. And she's sitting right there. I said, geez, I never thought I'd go to heaven, but there's the angel right there. But, we have the hearing. It looks like all indications are that the court's going to say there's no jurisdiction after the hearing. So the attorney comes in and he says, have I got a surprise for you? I said, good. What is it? I'm withdrawing our petition. That was nice. No petition for me. We'd have to start all over. I objected to the withdrawal of the petition under the CPLR because after 60 days or so, you got to get permission from the court, and you have to show the dismissal would result in prejudice. Okay, petition was not withdrawn. The decision was rendered. The attorney, nice guy, files a stay in the appellate division. I had my affidavits ready. We go in front of the 4th Department in Syracuse, and the judge's reaction to all of this was, you got to be kidding me. Are you sure you want me to do this, counselor? Yes. Denied, and it was affirmed by the rest of the panel. So the mom is in Ohio with the children. What time is it again? Okay. You want to hear the rest of the story about the Ohio case? It goes like this. The father went out to Ohio, or of the two children, on a day trip. And, hi, how are you? Went to the school, got the children. The kids came back, and Gracie was unable to walk. Gracie was having a lot of problems. Gracie, who's probably 10 at the time, could not walk because he raped her repeatedly. And we found later on that when he had Gracie from July into September, he was having sex with her. Daddy now is in jail for at least 20 years in Ohio, and I'm happy. And my client, she discontinued traditional methods of chemotherapy, went into some non-traditional methods. She's alive and well, and the kids, we believe, are doing okay. So that is my Ohio case. Now, after you get an initial child custody determination, people, and I'm not sure if you ever had cases, they're not always happy with the initial order. They want to modify it. So there are separate provisions in our practice, as you know, where people can come in and file a petition to modify a court. If everybody is in New York, the court will just treat it as a regular modification petition under the DRL or the Family Court Act. But if they live in a different state, then the same rules apply. Exclusive continuing jurisdiction still attaches. You can't file a petition in Kansas to modify a New York order if the New York court retains exclusive continuing jurisdiction and doesn't let go. That makes sense. But people do this. And generally what that causes is the following. Usually what I've seen is when one party in another state files a modification petition, then the other party in New York will most likely file an enforcement petition. Usually this happens in a situation where I want custody, you don't have home state jurisdiction, or they make all kinds of weird allegations in the other state. It all has to come before the court. When you get these type of cases, a modification petition where New York or the home state does not let go of it, but there's a simultaneous proceeding pending in another court, the court must communicate with each other, period. It's called must. It's not discretionary. And what does this mean? You can make the preliminary call, hi, how you doing? But whenever there's anything that's going on between New York judge and Kansas judge where they talk about the substance and who should have it, who should not have it, A, there has to be a record. B, there has to be an opportunity for the attorney and the parties to provide argument, legal argument, and possibly facts for the court to consider. It's not in a vacuum. A record has to be made. One case that I put in my outline for updates on cases deals with one judge somewhere who did it by email. That's fine. But the email communications are going to have to be on notice, and they're going to have to be shared with the counsel. It's not a secret court. Okay, it's not FISA. This is family court. All right. A modification petition, New York State will not. I'll turn it a little bit. Let's say that there was a case, an initial child custody determination made in Alaska, and somebody here in New York wants to modify it. New York can't modify that Alaska order. Don't fall asleep, please. Okay, it cannot unless a couple things happen. Number one, the state that has jurisdiction says, I don't want it. We relinquish jurisdiction. Then you can modify it. Or the parties, the child, the parents, or a PAP no longer live in that state. Florida is notorious, okay? Florida is probably the worst case that does this more often than not. And they do this. We will retain exclusive continuing jurisdiction, period. When all the people leave, they don't have it. It's gone. But they litigate it like you wouldn't believe. It's like they just don't want to give up. Our courts have been very good. Courts across the country that have dealt with the Florida weirdness have all said, you know, when the parties all leave, if nobody's living there, that state no longer has jurisdiction. Why they would want to keep it, only God knows. Pardon?
Is there a filing fee there?
Yeah. Well, that I'll give you the filing fee, and I'll give you a couple other little items. Number one, New York State is weird. We don't have filing fees. New York State is weird. We have an Attorney for Children program. New York State is weird. It's easy to litigate matters, and the state doesn't hold a financial matter over the litigant's head as a prerequisite to enforce their rights or require rights. So in some regards, this is good. Courts must communicate with each other. All right. Case number 2. And what time is it again, please?
It's 11:24.
Okay. Case number 2, Pennsylvania. As I said earlier in the presentation, a custody order, a child custody determination order can be made within a neglect case. Dad lives in Watertown. Mom lives in Camden, New York. Dad initially had joint custody, primary with the mom. He visits every other weekend with the child, comes down one weekend, mama is gone and the child is gone, disappeared. Where do they go? Well, we found them eventually in Pennsylvania. while on a rural farm. I don't know if there are any urban farms. While on a farm in a rural, urban setting, the CNY, Children and Youth, picked up the child, the baby, because the mother was being neglectful, put the kid in foster care. Finally, they find out that the kid had a father. Okay, they notify the father. Father goes down, tries to pick up the kid, and the court says, no. Your neglect order, your custody order is trumped by our neglect proceeding. Okay, never heard that before. Dad gets an attorney in Pennsylvania. They appoint a gal, a guardian ad litem for the kid, and the CNY, like DSS chief attorney, says, that's how we do it here in Pennsylvania. And are you really competent to tell us what to do in Pennsylvania? Aren't you really interpreting Pennsylvania law? I said, yes, I am. I like interpreting Pennsylvania law. And they go, well, you don't have any right to interpret Pennsylvania law. I go, yes, I do, 33815. And they go, what's that? I said, that's my bar number. I can interpret it. So we had a scenario where the kids down in, they're doing permanency hearings. They terminated, I think they terminated the mother's rights, and the child was being placed in a pre-adoptive home. Okay? And I called the attorney up and I say, what's going on? And she goes, well, you know, your client's a retard. I said, say that again? He's a retard. I said, oh, how do you know that? Well, he went to BOCES, and he was in some kind of disabled class, and that's why we done the psychologist. And I go, you did a psychological evaluation on this guy? Yeah. Why? Because he's a retard. I go, are you using that just, loosely? No, he's a retard. I said, okay. So I asked her 3 questions. I go, could you please give me the full name and address of your commissioner of CNY? Why? Could you give me the name of your commissioners in that county? Why? And I said, well, when I go to Scranton, I want to be able to have it all right. What are you going to go to Scranton for? I go, well, there's where the Middle District is located. Middle District of what? Federal court. Because I think what they were doing is trying to terminate my client's rights, 1, improperly, and 2, because he has a disability. Remarkable things happened thereafter. He wasn't a retard, and he was a hard-working junk picker up in Watertown. They gave him the kid back. All right. So one of the things that we frequently come into is temporary emergency jurisdiction. What happens when we're not the home state? We have no real basis to claim home state jurisdiction, but there's an emergency. Something has to be severe for the court to exercise protection. Why? Courts across the country really care about not wanting people to get hurt, especially kids. Under the UCCJEA, it was a very loosely defined definition of temporary emergency jurisdiction. It could be anything. My dog sneezed on me and I can't go back because of germs. It was just too loose. Now what the UCCJEA requires is it has to be a significant, it has to be real, it has to pose some serious risk to the child, and the child must be here. So if you have a client that says, my daughter in Illinois is having a problem and she's not getting medical care, where's the daughter? Illinois. You can't ask for temporary emergency jurisdiction here. It has to be real. If the court grants temporary emergency jurisdiction, it lasts for only a period of time, maybe, okay? What the court has to determine is there a serious risk that the child's going to get hurt, or the parent, or a sibling? And if they grant it, they'll put on a specified period of time that it is operable. Thank you. Watch what he's going to, he puts it on a, good man. All right. That's upside down. All right. They'll grant it for a period of time, and it expires. But before it expires, the court here is required to contact the court where jurisdiction lies and says, we need to plan for a safe return of the child. And a component within that is we also need to take provisions and make precautions so that this doesn't happen again. Just because we say the kid's going to go back to another state where jurisdiction lies, we want to make sure that the absconding parent isn't going to take off someplace else. Thank you. So what the law envisions is, let's say that temporary emergency jurisdiction is here. The left behind parent who has custody or visitation is going to do something. But not all parents do everything. A lot of parents couldn't care less, maybe, if their child is there or not there. If they don't do anything in the other state to file a petition for initial custody or to enforce a petition that they already have, an order that they already have, then you have a situation where New York, let's say, has granted temporary emergency jurisdiction and nothing happens. So under those circumstances, an order granting temporary emergency jurisdiction can ripen into a full jurisdiction. But for that to happen, if the court's going to allow it to ripen into home state jurisdiction or jurisdiction, the order that the New York court gives must say that. And it's not that bad. And we hereby accept and shall exercise jurisdiction. That's not bad, okay? You could even put a sticky up to give it to the judge on your letter. It's not that bad, but it has to be on there. Okay. The other day, somebody was coming up from Pennsylvania, and they saw Babes. Babes is a good place to stay, and what do? They dropped the kid off at Babes, and then after that, they went to California. An abandoned child is a child who comes under the jurisdiction of this court, okay? They're gone. They're abandoned. And if they're abandoned, the New York State can accept jurisdiction. It makes, a lot of laws do make sense, and you begin to question why we have laws, and I guess my answer would be something like this, because most people don't have sense. So that's why you need the law to give them some kind of sense. I'm going to move on. I talked a little bit about simultaneous proceedings. There's been a couple of cases recently decided by the appellate divisions, 3rd, 1st, and 2nd, that talk about don't believe what you read. That's basically what they're saying. Don't believe what you're reading when the people file these petitions. Even though it may be coined as a modification petition, it might be an enforcement petition, or maybe it'll be another type of petition. You got to look to the substance of the relief requested and the allegations to determine what proceeding they're trying to initiate in New York State. Does that make a difference? Yeah, because there's separate guidelines, whether in simultaneous proceedings, whether or not the court has to stay, dismiss, or enjoin the parties from going forward if they don't dismiss the case. So is it just mumbo jumbo technicalities? No. I would always oppose dismissal. I wouldn't mind enjoining them pending conferences or staying them in the other court if you could do that. But dismissing means if you agree to a dismissal, that's a consent order. Why are you going to agree to a consent order that you can't appeal? It makes sense. Inconvenient forum. If you take a look at 76F, 76F of the DRL sets forth a whole bunch of factors under which inconvenient forum has to be analyzed. And you often do this in conjunction with temporary absences from the state. Up until recently, there were absolutely no cases dealing with how does a court determine whether or not it's a temporary absence. The one case that came out was a miscellaneous case. It was great, and I'm happy it came out. It gave us guidance. And just recently, and I think that's some of the last 12 cases that I gave you in that outline, there's an appellate case that deals with temporary absences. For example, one case dealt with a dad moves out to, I think, Arizona, and then he stays there. Then mom brings the kid, she stays there. Mom goes out and gets a driver's license. She gets a bank account. She buys a car. She gets a loan. She moves in with her husband, and she does other things. And then maybe they had an argument. Maybe he didn't make the steak right, and she got mad at him. So she takes off to New York and says, "Hey, I'm back in New York, and I wasn't gone for 6 months. It was only temporary." And the appellate division said, "Nice try." No way. What you did, the conduct that you did, is indicative of not a temporary but a permanent move. So even under a situation where there hasn't been a full 6 months outside of New York State, you can transfer jurisdiction. Jurisdiction would be lost. It would go to the other state. Last case I think I'm going to chat about, which I think you're going to find, and it even includes an ethical issue, there is a section called DRL 76G, and that's jurisdiction declined by reason of misconduct. I mentioned this earlier, where the daddy took off with the kids and went to Oregon, or the child went to Oregon, and he said, Oregon now has home state jurisdiction. That court out there declined it on the basis of wrongful behavior on the part of the parent. It doesn't only apply to abductions. It could be a whole bunch of things. It could be domestic violence. It could be as creative as you can be if it's substantive and if it's true. We talked about the appearance of the parties and child in court during proceedings. Let's talk a little bit about Hague and PKPA, and then the last case on enforcement. The Hague Conference on International Abduction is really a great thing, basically because it's a treaty. And the signatory states have obligated each other to follow it. And not all the countries in the world are signatories. You can get a case. You can get countries like Jordan. Jordan is not a signatory. For the past 6 years, I've been trying to get a kid back from Jordan. No luck. It's discretionary. The Hague has a complete outline that I've provided as to what the law is and what the mechanisms are. The worry that I have, and I'm hoping it's going to be reversed, is that there's currently a Supreme Court case that talks about no equitable tolling of the child being removed from the parent in the United States. What does that mean? The case basically dealt with a parent taking off with a kid and hiding. And the parent tried their best to find where the child was. After 1 year, the Supreme Court of the United States said, yeah, it was wrongful, but if that new state or that new nation is not going to decline jurisdiction, and if the child has acclimatized, I can never say that, A-C-L-I-M something, acclimatized, become familiar with that nation, too bad. So in a way, our Supreme Court, way back, not too long ago, I think it was 2014, has taken that position. Fortunately, there are 2 circuit court decisions that are coming out where I think it was Sweden and another court said, even though that may be the case in New York, we're not going to condone it. We're going to send the kid back to the United States. The last thing before I say thank you, I'm done, is this. Enforcement. And this is going to tee in with a little ethical question for you. And I really want to see how you're going to react. We don't know, as attorneys for children, whether we're in a UCCJEA case all the time. Okay? If you see the different states, okay. If you see a DRL 76 petition, we know it. We're pretty bright on that. But what happens in a case like this? Mom is living in Rome, New York, and mom has a child, 8-year-old. School calling in CPS reports on the mom. The child's malnourished. The child is dirty. The child is crying. DSS will not remove the child. So finally, and she won't even bring the kid in to see me. brat. So finally, we get an order. The mom brings in the kid to see me in Rome Family Court. Okay, a little puny room to sit down with the kid and talk. All right, super. And I met with him, established a rapport, met with him the second time, and the second time I met with him, I said to him, what's going on, this and that. And he says to me the following, okay, and this is like probably after 2 hours of meeting him the first time. He says to me, I'm a bear, and I'm sitting as close to him or across the table. I go, oh, that's nice, okay? And I'm going, and I start on another topic, and he goes, I am a bear. I go, oh, I like bears too. I have bears in my office, like little wooden bears, stuff like that. He goes, no, stupid, I'm a bear. I go, what does that mean? I'm in Cub Scouts. He saw on my lapel my scouting pin. And I said, well, I'm an eagle. And we started talking. No clue. This is spooky, okay? So he starts talking, and I go, well, you like camping? Yeah, I like camping. Mom's going to take me to North Dakota, or North Carolina when we get done with this. I go, oh, that's nice. Well, I go, when did you go camping? I went camping with my daddy, but he died. I said, where? In Nevada. And I go, well, did you go camping with anybody else? Because the DSS petition said the father was deceased and there's no relatives anywhere. I said, yeah, I went with my uncle, Uncle Timmy. I go, okay, where does Uncle Timmy live? He lived where Daddy lived, in Las Vegas. So, all right. So is he telling me the truth? I don't know. I have very little to do. I'm lazy. So on a Saturday morning, I decided to call Nevada. And I did a skip church and some tracing. I find out Uncle Timmy's number. I thought it was Uncle Timmy. And call the guy up and say, hi, I'm Bill Kozlowski. I'm in New York. I'm the attorney for your nephew. What nephew? And I told him the child's first name. He goes, I'll sanitize it because I'm being taped. Is this a Frankfurter joke? I said, no, it's not a joke. He said, I don't know whether I should believe you or not. I'm the father. Okay? I said, where are you? In Nevada. We've been looking for this kid. There's warrants for the arrest of this child. There is an order of sole custody to me. How can I get my kid? I said, I better contact DSS. Next day we did have a meeting with DSS. DSS never told me that they had found out about this late the previous day. Wonder how they found out. But what bothered me was DSS took the position that we couldn't tell anybody that there was warrants for his arrest. And the sheriffs were not happy with that either. The father retained counsel in Nevada, pro bono, file a petition for enforcement, and down the road, the child was reintroduced to the father. Father came, got him in a therapeutic setting, and went to Nevada. Here's the ethical question. The day that he told me, I have one wish. I wish my daddy was alive. That was after I talked to the dad. How many people would have told the dad? How many people would have told the child? Nobody. Anybody? Raise their hands. Anybody would tell the child? All right. I did. I felt he should know. It was the happiest I've ever seen him. And mother wasn't too happy. But, like I said, there's a resurrection day for everybody, and that was the dad's resurrection day with his son. But outside of that, I could go on and on and on and talk, but I don't think you want to hear me anymore. All right. So I do have some more time. Yes, ma'am. Sure.
Yeah, okay. One of the things you said earlier was that a court can't order a parent to come back to New York State.
That's right.
But, okay, because I'm just trying to think in this in like a TEJ context, temporary emergency jurisdiction, because I've had a couple of cases, both of which I had the parent that took the child come here and claim temporary emergency jurisdiction. And in one case, I remember the court declined to exercise that in favor of California, where there was a custody order. And my client ended up having to go back to California with the child. And the other one involved South Dakota, and I don't remember exactly what happened there. But aren't there some in the enforcement
Yeah.
context? Isn't there
Yeah.
a situation
Yeah.
where the court could order that? And could you talk about that,
Sure.
please?
If the child wasn't here, but then in the pendency of the proceedings, the mom came back with the child, then the court could put the child in protective custody. And that's what they did in the case with Nevada. The child was already here. DSS didn't want placement, but once we found out that there were warrants for the mom's arrest and the fact that she was planning to move to North Carolina, the court ordered DSS to take custody of the child in foster care and also do those investigations from Nevada and from New York to find out what do we know about this guy. If the parent, out-of-state parent, comes into New York, the court does have the authority to transfer possession of the child if there is a meritorious basis to say that going back to the other state would be harmful to the child or expose the child to some kind of immediate risk of injury. But again, it's usually like courts like stability. And, you know, it's a toss-up whether you can demonstrate that if they make a limited appearance, whether the court's going to actually transfer possession. If they don't make a limited appearance, the court has discretion. I mean, total discretion. We had one with Judge Deep recently where New York had jurisdiction initially, and New York transferred jurisdiction to Missouri, and over the Christmas holiday, the boy comes for visitation with the mom in New York State, and mom keeps the kid, okay? Raised some kind of weird issues like the stepmother is mean to him, the boy wants a driver's license, he's only 14, and the boy wants to take certain cases or certain courses in high school. The boy was here in New York. Our court, Judge Deep, kept the kid here until litigation was filed in Missouri, and until he could sort through who was going to represent the child. It's a weird case. The mother brought back the child to New York, and instead of her hiring counsel, she took my client to a private attorney, and the private attorney said, "I'll represent you." So was this just a ruse on the part of the mother? Yes, I won't say that. Or was this a delay? Yes. Did the kid eventually go back? Yeah, we had communications between the court. Missouri court appointed a GAL for the kid out there. And ironically, I was a terrible person for this kid because he's in scouting. He's a star scout. We talked about him being a patrol leader, his dad being the scoutmaster, and he wanted to go back. But he can't tell that to mom. What can I say? Don't go into scouting. Nothing more. But did I answer the question?
If the situation is reversed from what I originally said, I mean, let's suppose you've got the client in New York and the other parent takes the child from New York and goes to whatever state.
Yeah.
Can't the client in New York
Yeah.
file a petition?
Yeah.
So then in that context,
Yeah.
can't the court order the child be returned here?
Yes. This court.
Okay, because that I think is different from what you said
If the court
before.
grants that order, then what you would need to do with that order is you go out to the county or the jurisdiction where the child is located, go to the California court, if that's the state. The California court would recognize that it has to be registered, and then the California court would issue an order directing law enforcement to go out and get the kid, bring the kid before the court, or in the alternative, if your client went to California to surrender the child there. Every state does that, The best state that I like dealing with is North Carolina, because they have their own rules there, for sure. The North Carolina sheriffs are fun. When you give them an order saying, go get the kid, they surround the home. And they just take the kid, and it's amazing, every single time. But, they should go to the judge. I mean, judges do count, Any other questions? No. Okay. Okay. Was I too facetious, or I can go on a little bit more? How about registering? You get an order from New York, and if you get an order made in New York, do you want to register it? Yes. How do you register it? Well, you go to family court or Supreme Court and you register it. There's no fee in family court. You got to give notice to the other party that you're registering an order, and the other party has a right to object. I don't like this order. It violated my due process rights, or there was a fraud committed. They have to have an opportunity to contest the registration of the order. If you have an order, let's say that mom and dad were all living in another state, and another state called Nebraska. Nebraska issues a custody order. Please take it here, okay, and register it. It saves a lot of aggravation and time later on. The wacko case that I had in Pennsylvania, when I called the prothonotary, that's the court clerk, the prothonotary says to me, I like to register the order in Pennsylvania. Well, it's over $200, all right? I said, well, I don't care if it's over $200. It'll have to be recognized. We don't recognize New York orders. I go, fine. That's why I was all the more irritated with them in that county for engaging in that type of behavior. It was absolutely horrific. And then the other thing I didn't tell you, the Pennsylvania case that we had, the judges wouldn't talk to each other. It was sad. It was Judge Brule. She did want to talk to this judge. He wouldn't talk to her. And what do you do? There's one case in the case notes that I gave where the judge made an adequate record of the attempts, several attempts to communicate on the record, and the other judge doesn't. What do you do when you get a judge who doesn't want to communicate? Best I can say is we had a family court judge here a while back named Frank Cook, and Frank Cook said to me one day, the last thing you want to do is to prod and poke and irritate a 500-pound gorilla. So I never prodded him, poked him, or did anything to irritate him. He always did his job. The Pennsylvania judge wouldn't. I didn't understand why. Judge Brule used to be a referee, and the judge down in Pennsylvania was a master, equivalent of a referee. So they both came from the same place. They went up the line. They just wouldn't talk to each other. Sad, Nothing else? Please do a critique. Let me know where I should change, how I should change, whether I should ever come back, or whether I should be banned from the podium again. That'd be good. All right.
Thanks a lot, Bill. It was wonderful.